This podcast covers civil procedure, evidence, and the appellate process. First, we will talk about the pretrial process under the Federal Rules of Civil Procedure. Step 1. The complaint is filed with the clerk of the court. This is the initial pleading by which a legal action is commenced. Under the federal rules, notice pleading is sufficient. A party just has to notify the opposing party of the allegations against him. Verification of the allegations is not required. The complaint must contain the basic elements of the cause of action. The complaint must include a caption which states the name of the court and the parties to the action. It must also include a short statement of the jurisdiction which tells us why the case is in the proper court. This could be due to the residency of the parties, or where the action arose, meaning where the accident occurred, the contract was signed, or the property is located. The complaint must also state the relief requested or the damages. This could be either equity, which means specific performance, or legal damages, meaning money. A signature and a date must be on the complaint. The attorney or the client must sign it, not a paralegal. The plaintiff can demand a jury trial in the complaint. If the plaintiff fails to do so, the defendant may demand a jury trial in the answer. A jury trial means that the issue of fact will be decided by an impartial jury. If a party does not demand a jury trial, he waives his right and there is a bench trial, which is a trial without a jury where the judge decides issues of fact and law. Arizona is a notice pleading state. All that must take place is the other party must be notified of the allegations of the claim or of the defense. There must be a short, plain statement of the basic elements of the claim or of the defense. Here is an example of a complaint for a negligence case, Bob versus cab driver. On April 20th, 2020, Bob was walking on the sidewalk of Camelback Road in Phoenix, Maricopa County. Bob fell down in the street. Cab driver was traveling on 20th Street and was not looking where he was going. Cab driver should always look where he is going when driving his cab. Cab driver owes the general public and Bob a duty of care to be observant and drive reasonably. Cab driver had plenty of room to stop if he was looking where he was going. Cab driver was not looking where he was going, but was looking at a prospective fare. Because cab driver was not looking where he was going, cab driver ran over Bob. Bob was injured when cab driver ran him over. Bob incurred medical expenses. The facts should be kept simple. Notice that the complaint hits upon all of the elements for negligence. Cab driver owed Bob a duty of care, number 1. Number 2, cab driver breached that duty. Number 3, Bob was injured. And number 4, cab driver's breach was the proximate cause of Bob's loss. In this slide, you can see what an actual complaint, an example of what an actual complaint looks like. In the West Phoenix Justice Court, Maricopa County, Arizona, this is the caption, Bob Blindman Plaintiff versus Helpful Harry Defendant. And then you have the civil action number, which would be filled in with the actual number. Underneath it, complaint. Number 1, Bob Blindman lives at 2001 East Camelback Road in Maricopa County, Arizona. Helpful Harry lives in Maricopa County, Arizona. All events set forth herein occurred in Maricopa County, Arizona. Number 2, Bob is 75 years old. Harry was at least 18 years old on January 1st, 2013. Number 3, on January 1, 2013, Bob and Harry entered into an oral contract. Harry agreed to bring Bob grocery shopping every Tuesday for 6 months. Bob agreed to pay Harry $10 a week or $40 a month for his service. Number 4, in April of 2013, Harry refused to bring Bob grocery shopping. Harry breached the oral contract and has refused to perform under the contract. Number 5, due to Harry's breach, Bob has been injured. Bob had to run another advertisement in the Arizona Republic, which cost him $25. Bob hired Shirley to bring him to the grocery store every Tuesday and had to pay Shirley $60 a week. Number 6, Bob praised the court to award him compensatory damages, $745 in compensatory damages. Bob praised to the court to award him costs and attorney fees. Number 7, Bob demands a trial by the court, signed Bob Blindman or attorney for Bob Blindman. Again, you can see the caption is proper and all the basic elements of the cause of action are set forth. The facts are kept simple. After the complaint is filed, service of process is made. This is step 2. In this step, notice is given to the defendant to afford him an opportunity to appear and be heard. The summons is the instrument used to give notice to the defendant that the lawsuit has been filed against him or her. Plaintiff is responsible for proper service of the summons. The summons and the complaint may be served on the defendant by mailing copies to the defendant along with notice and acknowledgement of service. If the defendant fails to acknowledge receipt of the summons and the complaint, service is not complete. Plaintiff must then send a U.S. Marshal or process server to physically serve the defendant. A process server can be any person who is not a party to the lawsuit and is at least 18 years old. In Arizona, the process server must be 21 or older. Next, the answer is filed. This is step 3. The defendant has a limited time to file an answer, usually 20 days, or he risks judgment against him by default. The answer must admit the allegations that are true, deny the allegations that are not true, or state that he does not have sufficient knowledge regarding an allegation. The allegations which are admitted as true need not be proven at trial. Any allegation which is not denied is presumed to be admitted. The answer must allege all of the defendant's affirmative defenses. If not, they are waived. For example, in the case of Bob versus Harry, defendant Harry might admit the jurisdiction so that all events took place in Maricopa County might be admitted. He might deny Harry's age and claim that Harry is only 17 years old. The defendant might state that he is without sufficient information as to where Harry lives. And defendant Harry might raise as an affirmative defense lack of capacity. After the answer is filed, discovery begins. This is step 4. This is the pretrial period when the parties exchange information that is relevant to the case in preparation for trial. During this phase, the court is available to help facilitate the process. So, for example, if a party does not comply with the discovery order, the court can hold the party in contempt of court. The purpose of discovery is to prevent surprises at trial, encourage settlement, and facilitate a just result. Information that is allowed to be obtained during discovery is information that is relevant to the legal action. This concept is usually interpreted broadly by the courts. Information that will not be disclosed by the parties because it is legally protected is information that is privileged. For example, the attorney-client privilege protects conversations between the attorney and the client. The attorney's work product, such as notes regarding legal strategy, is also protected. In criminal cases, a defendant cannot be compelled to testify against himself. He is protected in this regard. There are several methods of discovery. The first are interrogatories. These are written questions about the case submitted by one party to the other party. They must be answered under oath and once completed, need not be proven at trial. Next are depositions. These are testimony of a witness taken outside of court and under oath, and a transcript of the session is made. They are similar to the type of questioning you would see in a trial during direct and cross-examination of a witness. Both sides are present and have a chance to question the witness. Depositions are important for 3 reasons. First, the attorney can gather important information about a case. Second, the depositions can be used later at trial to impeach a witness. For example, if a witness says in his deposition that he saw the defendant's vehicle spin out of control, but then changes his story at trial and says he did not see the defendant's vehicle before the collision, the deposition can be used to impeach his testimony. Third, the deposition can be read into the trial record if the witness cannot be present at the trial. The last method of discovery is a request to produce. This is a request served on a party who has relevant documents and can be used to gain entry to that party's premises for purposes of inspection, photographing, and copying relevant information. The court may order compliance with the request. After discovery is complete, pre-trial conferences take place. This is step 5. The attorneys' conference is where attorneys for both sides meet to discuss the results of the discovery process and begin settlement negotiations or prepare for trial. Settlement is usually a goal, as trial outcomes are uncertain and cost a lot of time and money. The judges' conference is where attorneys meet briefly with the judge to submit matters discussed at the attorneys' conference. The judge can grant a motion for summary judgment. This is where one of the parties files a motion claiming there are no genuine issues of material fact, meaning the only questions in dispute are issues of law. He or she might be entitled to prevail as a matter of law if the court agrees. If no settlement is reached or motion granted, trial comes next. The jury selection process begins. This is known as voir dire. It consists of a preliminary examination of jurors where their competence and objectivity to serve as jurors may be questioned. There is usually a screening device to eliminate those jurors who are incompetent or whose government employment may present a conflict of interest. Those convicted of felonies and law enforcement officers may be excused, but not always. How are jurors selected? First, trial court clerks select potential jurors from voter registration lists in the judicial district. Jurors must show up or give a good excuse as to why he or she cannot serve. Otherwise, he or she is subject to being held in contempt of court. Once potential jurors are gathered, there is an opportunity to challenge them. There are 2 types of challenges. First is a challenge for cause. The parties have an opportunity to remove some jurors for cause. This means they must state a valid reason. Each party is allowed an unlimited number of these challenges. This is how it works. Either the judge or the lawyers ask the potential jurors questions dealing with their potential bias or incompetency. One of the lawyers can move that the court disqualify a juror for cause. The other lawyer can present opposing arguments concerning the challenge for cause, and the judge then decides whether the request will be granted. In other words, whether the juror will be removed. The goal here is to create a fair and impartial jury. An example of some of the questions which might be asked are whether any of the potential jurors are related to any of the parties in the case, or to any of the parties' attorneys, or to any of the witnesses to the case, or whether any of the potential jurors have personal dealings with any of those people. The second type of challenges are preemptory challenges. Here, the parties have an opportunity to remove some jurors without cause, or this means without having to state a reason. Each party is allowed a fixed number of these challenges. The amount varies by state. Arizona generally allows 6 strikes. Once the jury is selected, trial is almost ready to begin. First, the jury needs preliminary jury instructions. The judge instructs the jury that their role is primarily to decide what the facts are from the evidence shown at trial and to apply the law to the facts. The jurors must apply the law even if they don't agree with it. Now the jury is ready for opening statements. This is when the lawyers for both sides give a summary of each side's version of the facts, or their version as to what really happened, and a heads up of what the jurors will see throughout the trial. That is, who will testify and what each witness will say. Opening statements are not evidence because they are merely a party's argument as to what really happened. Examination of witnesses occur next. The plaintiff's witnesses go first. First is direct examination. This is examination of a witness by the attorney who calls the witness. Leading questions are not allowed during direct examination. This means that during direct examination, the lawyer cannot ask questions that put words in the witness's mouth. Cross-examination follows direct examination. This is examination of a witness called by the opposing counsel. Here, the lawyer may use leading questions and often begins with, "Isn't it true that?" The goal with cross-examination is to attack the credibility of the witness. One way to do this is to show that the witness is not truthful or does not have her story straight. Redirect examination follows cross-examination. The attorney who conducted the direct examination has the chance to examine the witness again to try to rehabilitate the witness following a cross-examination. In other words, the attorney has the chance to recapture the witness's lost credibility. Expert witnesses are often key witnesses. An expert witness is one who has specialized knowledge in a particular field, obtained either from education or personal experience, that qualifies the person to answer what are called opinion questions. For example, a qualified expert is allowed to testify that if a certain set of facts occurred, her opinion as to what caused the accident is the following. An ordinary witness would not be allowed to testify to this. Plaintiff has the initial burden of proof. So plaintiff must establish that the evidence will prove her case. After the plaintiff finishes her case in chief, the defense may move for a directed verdict in favor of the defense. The defense may allege that the plaintiff has failed to prove her case, and the trial court should enter judgment in favor of the defense. If the directed verdict has been denied, the trial continues. Next comes the defendant's case in chief. This is where the defense calls its witnesses. After the defense has called its witnesses, now the plaintiff can move for a directed verdict in her favor. She can say that the defense has failed to refute the plaintiff's claims and judgment should be entered in favor of the plaintiff. She is arguing that the case need not go to the jury. After the directed verdict is denied, if it is denied, in that case, then the next step are closing arguments. This is where each side summarizes the evidence and gives his version of the facts of the case. The attorneys tell the jury why it should not believe the other side. After closing arguments, the next step is the judge's charge to the jury. This is where the judge instructs the jury on the law. Next comes the verdict and the judgment of the court. With the verdict, the jurors deliberate and decide on a verdict or a formal decision in the case. With a judgment, after the jury arrives at a verdict, the judge enters a judgment, which is the official decision in accordance with the jury's verdict. Sometimes there is a judgment notwithstanding the verdict, also known as a JNOV. Before the judge enters the judgment, the parties may object to the verdict. The judge can enter what's called a judgment as a matter of law. This means the judge can overrule the jury verdict if a prejudicial error has occurred. Judges are very hesitant to grant these JNOVs and also directed verdicts, which we discussed a few minutes ago. Judges look very carefully at the evidence before granting either of these types of motions. The party requesting the JNOV or a directed verdict, that party has a very high burden to show that they are entitled to either the JNOV or the directed verdict. They are not easily granted. We are now going to turn to discuss the rules of evidence. The rules of evidence govern the admissibility of evidence. Attorneys object if the rules are broken. The judge decides if a certain question should be asked or if a physical object should be admitted. If an attorney objects, she cannot generally state, "I object." She must be specific and state why she is objecting. For example, objection hearsay, objection leading, objection calls for speculation, objection asked and answered, objection calls for an opinion, objection relevancy. A general but important rule regarding evidence is that all evidence must be relevant to the issue being decided. A leading question is a question that suggests or implies the answer. It is not open-ended. It is not permitted on direct examination, but is permitted on cross-examination. For example, wasn't the car metallic blue is a leading question. What color was the car? That is a non-leading question. You were standing in front of the bushes, so you had a clear, unobstructed view when you saw the defendant stab the victim, didn't you? That is a leading question. Where were you standing when the victim was stabbed? That is a non-leading question. These are also non-leading, or also known as open-ended questions. Where were the bushes? What could you see? Was there anything obstructing your view? Here is an example of a leading question. You purchased the car based on the reputation of the manufacturer and advice from the dealer, didn't you? This is a non-leading question. This is non-leading because it is open-ended. What were some of the factors you considered when purchasing the car? Hearsay is defined as an out-of-court statement. It can be spoken or written. It is used to prove the truth of the matter asserted. What does this mean? The idea is that Wendy is testifying as to what Dennis told her, and this is secondhand information. We want the best evidence, not secondhand information. This secondhand information is considered hearsay and thus inadmissible. If Dennis made the statements, Dennis should be in court testifying as to what he said, not Wendy. The usual rule is that hearsay is inadmissible in court. However, there are exceptions when the law says that hearsay is reliable enough that the court will allow it. One of those hearsay exceptions is an admission by a party, a confession to police officer, or other statement accepting fault. If a party confesses to a crime, that confession is admissible, even if it is hearsay. The reason is that the party is probably telling the truth, as a party would not joke or lie about something like this. At least that is the rationale. Here are a couple examples of hearsay. Defendant is accused of stabbing victim. John was a witness to the stabbing. John tells his girlfriend that he saw defendant stab victim. Defendant then brags to Al about stabbing the victim. At trial, John, who told his girlfriend about the stabbing, John is nowhere to be found. The prosecution calls girlfriend. Can girlfriend testify that John told her that he saw defendant stab victim? Now remember, we want our best evidence, so we would rather have John be the one to testify, but because John is nowhere to be found, can the girlfriend stand in his place? Well, it's hearsay, it's secondhand information, so no, girlfriend cannot testify. The statement is hearsay, and there's no way to cross-examine John's statement. There is no exception that applies. Now let's say the prosecution calls Al. Can Al testify that the defendant told him that he stabbed the victim? Is there an exception here? That Al can testify that the defendant told Al that he stabbed the victim. Now that is also secondhand information because he's claiming that the defendant told him that he stabbed the victim, so the defendant should be the one on the stand, not Al. It is hearsay, but here, even though it's hearsay, it falls under an exception. It falls under the party admission exception to the hearsay rule. Defendant, in this case, admitted to Al that he committed a crime. The defendant admitted that he stabbed victim. Even though this statement is hearsay, it is secondhand information, and the defendant is not available to testify. The defendant was probably telling the truth, so the law allows it. Most defendants or most individuals will not run around admitting that they committed crimes, that they stabbed other individuals, unless it is true. So that is considered an admission by a party. It is, again, an exception to the hearsay rule, and the law allows it. Let's talk about an example you are probably all familiar with, a case, the O.J. Simpson case, involving evidence. Some of you may remember, and others may be too young to recall, the 1995 criminal trial of O.J. Simpson. Yet you, I'm sure, are familiar with the case. In any event, in that case, the prosecution argued that Simpson killed his former wife, Nicole Brown Simpson, and that the murder was the culmination of a long pattern of domestic violence. The prosecution discovered in a safe deposit box journals that Brown Simpson had written concerning her problems with Simpson. The journals actually contained graphic language and described episodes of physical violence and threats committed by Simpson. They appeared to be a strong demonstration of the couple's relationship, but they were never entered into evidence at the criminal trial, and Simpson was acquitted in the killings of his former wife and her friend, Ronald Goldman. These journals were inadmissible because they were considered hearsay evidence. In her journal, Brown Simpson told readers what Simpson did to her. With her death, there was no way for the defense to challenge her memory, perception, and sincerity about what she had written. Obviously, she wasn't available to be cross-examined as to what she had written in those journals. The rules of evidence view such non-challengeable out-of-court statements as unreliable when they are intended to prove their very truth, which they were. They were intended to prove the truth of the matter asserted. They are, for that reason, hearsay. And here, yes, they were intended to prove the truth, that Simpson had beaten Brown, stalked her, and made her fear for her life. For the same reasons, those journals were not admitted at Simpson's civil trial in 1997. There was a civil trial after the criminal trial. In that trial, Simpson was found liable for the wrongful deaths of Brown Simpson and Goldman. Okay. Arizona Rules of Evidence covers these topics. The rules 801, if you look up the rules in the Arizona Rules of Evidence, you will find that 801 covers hearsay. 803 covers all the hearsay exceptions, and Rule 702 covers opinion testimony. Let's now turn to opinion testimony and talk about who is qualified to give an opinion in a court of law. A regular fact witness is not qualified to give an opinion. An expert witness is qualified to give an opinion. So what does it mean to be deemed an expert? An expert is someone with specialized knowledge or skill in a particular field obtained through education, training, or personal experience. Some particular knowledge which is not possessed by the average citizen. For example, a psychiatrist who examined the accused may offer her opinion on the accused's sanity. Another example is fact testimony about a car accident might include testimony about the skid marks behind the plaintiff's vehicle, but a qualified expert can analyze those skid marks and testify as to an estimate of the defendant's speed. So an ordinary fact witness wouldn't be able to do that, but an expert can testify based on the skid marks, can estimate how fast the defendant was traveling. Now, the opposing party can object to the opinion testimony on the basis of the expert's lack of qualification. And in that case, the trial judge will have to rule on the expert's qualification. Why do we need expert witnesses? Well, experts help the jury understand complex cases or cases with unusual facts. Experts give their opinion as to what occurred, so the jury can choose to believe or not believe the experts and sometimes not have to make their own guesses. The downside of experts is that oftentimes the case comes down to a battle of the experts, and the jury just does not know who to believe. The plaintiff's burden of proof in a civil case is preponderance of the evidence, which means that something is more likely than not, which also means it must be 51% or greater. The burden of proof in a criminal case is beyond a reasonable doubt. Verdicts in a civil case do not have to be unanimous. For example, 6 out of 8 in favor of the plaintiff meets the burden of proof. In a criminal case, verdicts have to be unanimous. So they can be sometimes if the jury is a panel of 6, so all 6 jurors have to decide, or a panel of 8, it has to be all 8, or a panel of 12 jurors, all 12 must decide. After trial. JNOV is a judgment notwithstanding the jury's verdict. We briefly spoke about this with regard to civil cases. We said that the judge may alter the jury's verdict, and the judge may do that on liability or damages. With regard to a civil case, the judge may change the jury's verdict on either liability or damages. The judge may also grant a new trial in a civil case. In a criminal case, the judge may grant a new trial. We are now going to discuss appeals. There is no constitutional right to appeal. The right to appeal is created by statute. The time for an appeal is 30 days from the trial court's entry of judgment. The appellant is the party who brings the appeal. The appellee is the party against who the appeal is filed. The function of the appellate court is error correction and law development. The appeals court job is to correct legal errors. They do not try the case again. Also, if there is an area of the law that needs clarification, for example, a statute is vague, the court will add clarity. This is what is meant by law development. The appeals court can do one of three things after it hears a case from the lower court. It can affirm the lower court's decision, number one. Number two, reverse the lower court's decision. And number three, it can remand the case back to the trial court with directions. Again, it does not try the case again. New facts or newly discovered evidence is not considered or examined. There is a three-judge panel which hears each case. A majority decision is made, so 2 out of the 3 decide the case. In an appeal, the appellant, which is the party bringing the appeal, has the burden of proof to show prejudicial error occurred in the lower court. It has to be more than just a harmless error. It has to be some sort of prejudicial error occurred. For example, there might have been hopeless confusion of the jury, some sort of crucial evidence was admitted or not admitted. There might have been incorrect jury instructions. For example, the elements of a crime or a cause of action. Possibly a constitutional right was violated. And again, the appellant must show that the error was not just harmless error that occurred. So, for example, if leading questions were asked, that is most likely going to be harmless error. Or if counsel went beyond areas of cross-examination in redirect, again, that's going to be harmless error. The basis for an appeal can be a question of law or procedure. It cannot be a question of fact. It is the jury's job, not the appellate's court job, to weigh the evidence and determine the credibility of the witnesses. The Court of Appeals does not determine questions of fact, and the reason for this is the jury is the finder of fact. The appeals court will not second guess the jury. Again, the jury, they are the finders of fact, nor will the appeals court substitute its judgment for the judgment of the jury. The appeals court cannot just say that they are dissatisfied with the trial outcome. The effect the appeal has on the judgment: for a civil case, it stays the payment of the trial damage award. For a criminal case, generally nothing. The defendant remains in prison or remains on probation as the appeal is processed. Oral argument is granted in an appellate case only if deemed necessary by the 3-judge panel. Res judicata occurs when all opportunity for an appeal has been exhausted. The case is finally decided and cannot be the subject of a future lawsuit involving the same parties. This concept means that the parties are estopped from bringing a future suit involving the same parties and the same issues. An example is a plaintiff who gets in an auto accident and sues the driver of the other auto under a theory of negligence. The plaintiff loses, and plaintiff then files a second lawsuit alleging additional facts that would help her prove the other driver was negligent. A court would dismiss the second lawsuit under res judicata because the second lawsuit is based on the same cause of action, negligence, and the same injury claim. Another example is a plaintiff who gets in an auto accident and sues the other driver alleging negligence and loses. Then the plaintiff decides to bring a lawsuit based on the same accident, this time alleging that the driver intentionally struck her auto. A court would assert collateral estoppel because the plaintiff could have alleged an intentional tort cause of action in the original complaint. And this collateral estoppel is very similar to the idea of res judicata. In both cases, the plaintiff is stopped from bringing that second lawsuit because the plaintiff could have asserted the additional facts or the additional legal theory in the first lawsuit. This is the end of the podcast for civil procedure, evidence, and the appellate process.